started discussion of third-party notice. Third-party notice. Remember? And we said that we are required to, by the syllabus or the manual, to understand the nature, the policy foundations of third-party proceedings. We're also supposed to have the knowledge of the procedure and drafting of an application seeking leave to issue a third-party notice. We are also required to have knowledge of the service of third-party notices and obligations imposed on a third party to enter appearance and defend the action. Then we're also supposed to appreciate the doctrinal connection and distinction between indemnity, contribution, and other reliefs. And we are also supposed to have knowledge of the course control over third-party proceedings, including directions, just as other the substantive action the court will manage it. So what powers has the court got when it comes to third-party proceeding? So third-party proceedings or third-party notice, if you look under 15, the language there is third-party procedure, a third-party procedure. Now it is where, very simple. Let's illustrate it before we even look at the conceptual definition. So let's take this scenario. Let's suppose that, and that is why I like Mr. Kwame Tete. He has a very simple illustrations in his work. So supposing you are in a traffic, we have maybe, let me illustrate here. We have, let's say, car A, car B, car C. And let's suppose that car C was driving carelessly so that it ran into car B. And as a result of which, car B also pushed car A into the gutter or somewhere. And then car A got badly damaged. Now, the car A, the driver, of course, so car A is angry. He wants to take an action. Car A knows that it is car B which hit it from behind, isn't it? But car B knows that it is innocent. It was rather pushed by car C. But as far as car A is concerned, he doesn't care about whatever is between car B and car C. All that he knows is that it was pushed into the gutter by. So he decided to sue car B for damages from negligence and so on. So when it has sued car B will do the civil defense and everything. But then car B will be maintaining the argument that, well, car C is the one which forced it to damage. So it has also got a claim against C. And that claim will actually enable him to satisfy whatever claim A is making against B. But as it is, B is a defendant. B is a defendant, and B cannot just apply to have C join as a co-defendant. No, it doesn't work that way. Because he is not saying that it's not a question of like being like another defendant. So B is saying, yes, I have either, in this case, we call contribution, that whatever I cause you, I didn't cause it to you or myself. I was pushed. So somebody contributed to the wrong for which you are liable. So this B would like to come to the courts on application, as part of application, and to explain to the court that he has a maintainable cause of action in the form of, let's say, a contribution against C regarding what the plaintiff A is demanding from him. So the court should allow him to serve a notice of a third-party procedure on C regarding whatever contribution that he's claiming. Because as it is, if B just concentrate on defending the action against A, B knows that he's likely to lose. He knows like what A is saying. A has a point. But then he knows that when he didn't just force it to A. He was pushed to cause whatever damage A suffered. So must B wait, finish the case with A. A will get the judgment against B. And then when A is executing the judgment, then B will now start an action against C that you should come and also pay or either compensate me, or I don't use indemnity because it doesn't arise just on a simple fact, but that you should be made to pay whatever compensation that your negligent driving has cost. And it's also and part of that, part of his claim will be that he has been exposed to liability to A, and then the judgment has been obtained against him by what? By A. So if you are not driving carelessly, I wouldn't have driven into A. So all those things are some of the things that will be asking the court to allow him to get a judgment against him. Now, B need not wait for that to happen. You need not wait for A to get the judgment. Particularly so, where it will be in even C's interest, will also be part of the proceedings. Because C has an interest. What interest has it got? If it is true that C caused B to run into A, then C should be interested in helping even B to resist the claim which A is making against what? Against it. Because if he doesn't help B or is not able to defeat the claim of A against B, and A is successful against B, B will definitely go after him, isn't it? Yes, so basically, so that is in a very simple illustration how a third party may play a bad so many other illustrations we will be looking at. So we read Order 15 the last time. Order 15 1. We read it just before we ended the class last week. So the person sued by the plaintiff is not always a person who should ultimately bear the loss. Just like the car A, car B, car C example. Now car B is sued by car A, isn't it? Yes. But as you know, car B is not the person or the entity ultimately to bear the loss. It's car what? Car C, yes. Of course, for the plaintiff will focus on the immediate event which caused his grievance. He doesn't care that it was somebody who's also caused it. And that is why a third-party procedure may become necessary. But there is a very important illustration which was given in a case I'd like all of you to look at. Barclays Bank against Tom. Barclays Bank against Tom. 1923 1 KB 221. If you read Mr. Kwame Tete's work, he also cited Lord versus SCRUTTON Law Justice Scrutton, or somebody who says Scrutton, explain how third-party procedure works in a very simple terms. And I'm quoting his lengthy explanation, so just pay attention. I'm quoting Law Justice Scrutton. Quote, it is important to keep clearly in mind that the third-party procedure is, he said it's important to keep clearly in mind what the third-party procedure is. Then he continues. So he's speaking, Scrutton speaking. A plaintiff has a claim against a defendant. The defendant thinks that if he is liable, he has a claim over against a third party. So just like what we did. With that matter between the defendant and the third party, the plaintiff has clearly nothing to do, not being concerned with the question whether the defendant has a remedy against somebody else. So you take A and B and C. A is not interested in whether B has a remedy against what? C, concerning the matters that A is trying to take B on. Then Lord, that's the scrutiny continues. But the defendant is much interested in getting the third party bound by the result of the trial between the plaintiff and himself. For otherwise, he might be at a great disadvantage if, having fought the case against the plaintiff and lost, he had then to fight the case against the third party, possibly on different materials, with the risk that a different result might be arrived at. The object of the third party procedure is therefore, in the first place, to get the third party bound. I'm still quoting him. To get the third party bound by the decision given between the plaintiff and the defendant. In the next place, it is directed to getting the question between the defendant and the third party decided as soon as possible after the decision between the plaintiff and the defendant, so that the defendant may not be in a position of having to wait a considerable time before he establishes his right of indemnity against the third party, while all the time the plaintiff is enforcing a judgment against the defendant. And thirdly, it is directed to saving the extra expense which will be involved by two independent actions. With these objects in view, the third party order usually provides that the third party may appear at the trial between the plaintiff and the defendant. When the third party has so appeared as a party to the proceedings, various questions arise as to what he can do. Can he counterclaim against the plaintiff? The answer is no. For such a counterclaim will have nothing to do with the issue in the action, to which he is admitted as a party. Can he interrogate the plaintiff? The answer is yes. That is, can he cross-examine the plaintiff? The answer is yes. If the object of the interrogatories is to show that the plaintiff's claim against the defendant cannot be supported. I remember in one case in which I was a counsel, the third party, the judge talking about the experience when he was alive before becoming a judge. I remember in one case in which I was counsel, the third party was on the same principle allowed to raise a defense on behalf of the defendant, which the defendant would not raise on his own behalf. When it has been ascertained that the defendant is liable to the plaintiff, the next step is to try in such a manner as the judge may direct the question between the defendant and the third party. The defendant says, quote, "You owe me so much by way of contribution or indemnity." How may the third party defend himself? Of course, he may deny that he is under any such liability at all. But he may admit his liability and say that he has a cross claim against the defendant. which prevents any effective judgment being given against him. You may say, your right contribution will result in £100 being due from me to you. But I have a set off in another matter in respect of which £100 will be due from you to me, unquote. So, Lord Justice Scruton LJ dicta is a very good and comprehensive overview of what the third-party procedure what is. And that is what we also attempted to illustrate with the cars A, B, and C. So the rationale or the policy foundation is to avoid multiplicity of what? Suits, bring finality, and also ensure coherent allocation of liability. Yes. The title. Oh, I said Barclays Bank. Barclays Bank against Tom, T-O-M, Tom. 1923, 1 KB, 221. 1923. When most of you were born. Yeah, so if you look at order, look at order 15, rule 1, it talks about those situations in which a third-party procedure or proceedings may be permitted. So first, that the defendant is entitled to contribution or indemnity from the third party. So when we say indemnity, what is indemnity? So we are saying that the defendant will be allowed to have a notice of third-party procedure served on the proposed third party if he can show that he has indemnity or contribution against that proposed third party. And what is indemnity? Immediate position, okay. Before, okay. All right, good. Yeah, so can you give, no, you remember your agency law? Principal in what? Agent. Good. Remember you've done law of trust. Trustee, beneficiaries, and then the trust fund, and so on. Good. So indemnity is a claim by the defendant that if I, the defendant, am held liable to the plaintiff, then the third party must reimburse me in full or hold me harmless for that liability. That is all that it means. And that is why if we take an agency principal, the agent is the one representing the principal, in transaction, isn't it? Despite the fact that it's even like a disclosed principal. There are some third parties who may not bother to go beyond the agent and look for the principal. They will just sue the principal, isn't it? And whatever judgment which will go against the agent, the principal will have to indemnify, isn't it? It also goes the other way. In some cases, the agent will also have to indemnify what? The principal. So, for example, especially when it comes to employee-employer relationship, you have a driver and you send your driver with a car to go and deliver something. And then the driver decides to go and visit his girlfriend with the car inside. So he makes a detour, isn't it? It's on the flank of his own, yes. So he decides, okay, I think you're more comfortable with that than the. All right. Okay, I see you are sophisticated criminals. So like that, okay, it's also on the flank of his own. So unfortunately for him, maybe the day was not a good day for him, or he didn't pray. And then the car ran into somebody's house. And then the house, let's say, damaged or like everything was demolished. Now the car owner, the house owner will sue the car, the driver, isn't it? And then he will trace it and find out that the owner is you. Maybe Mr. X is the owner, then we're just the driver. So vicarious liability will do what? Will come in. So you sue the driver and the principal, vicariously. The principal can only be weeping, but you have to defend the action. Now, but the principal also know that he didn't create the mess. So you go through, but the driver will have to indemnify the principal, the owner, because you going on the failure of your own is not part of the mission, isn't it? But it's my car. So once there's a problem, I have to bear whatever comes. But between the owner and the driver, the owner has a claim against the driver. But it's not the owner is not the plaintiff. The owner is what? Is a defendant. A defendant who has a claim of indemnity against another what? Defendant. So that is another third-party procedure, except that the procedural requirements will vary a little bit. As you go through, if you are a proposed third party completely outside and you are here to come in, you have to enter appearance and do all those things. But here's the case, you've also been seen as what? As a defendant. Let's say you as a driver, you're probably like the first defendant, and the owner is the second what? Defendant. And then the owner, second defendant is saying that I also have a claim of indemnity against the driver, because that particular location where the accident happened is never part of the places that I send him to go and carry my lawful activity. So he will have to pay everything. Then he also has that against him. So that is another example of what? Indemnity. And indemnity, as you can see, is complete shifting of loss. So here, the owner is trying to say that, yes, you have the victim, that is the owner of the house, you have a claim against me with respect to the demolished building caused by my car. But I'm not the one to really bear it, because the driver was on the floor of what? Of his own. So he should actually bear it. So the number, it can agency, trusteeship, employment, partnership. Contract. Sometimes you can have a contract in which you have an indemnity clause over there. That if certain losses occur, somebody is supposed to indemnify what? The other party, as it were. The case I'd like you to read, and also the negotiable instrument to also have the issue of indemnity also coming up in a sense. So Barclays Bank against Hurley Enterprise. Barclays Bank is a high court decision, but I think the scenario is an illustration of some of the things we are talking about. So Barclays Bank Ghana Limited against Hurley Enterprises. Hurley. Then into bracket, Kofi Chrome Company Limited, third party. So when you have like a third party, case with a third party procedure, if you look at the title, it will reflect as such. So Barclays Bank Ghana Limited against Hurley Enterprises, then into bracket, Kofi Chrome Company Limited, comma, third party, bracket close. So here, basically, the plaintiff was seeking to recover a liquidated sum of $12,000, a little over it, plus interest from the defendant, Hurley Enterprise. And how did the debt come about? A check was issued in favor of the defendant, Hurley Enterprise, the check was issued by Coffee Chrome Company Limited, and the check was deposited in the account of Helen Enterprise held at the Barclays Bank. Now, when the check was deposited, they credited the account, and the defendant withdrew some of the money, started using it. But then when he went to clearing, the bankers know when he went to clearing, it couldn't go through. So it was dishonored. And then the bank decided to demand refund from the defendant. So the defendant admitted and started paying, but had not finished paying. So the bank decided to sue the defendant to recover the outstanding. And then when the defendant was sued by the bank, the defendant, that is the enterprise, Helen Enterprise, having admitted benefiting from the dishonored check and agreed to pay the debts, applied to have a third-party notice issued against Coffee Chrome Trading Company Limited, saying that Coffee Chrome Company Limited is responsible for the check going through, because they issued the check in favor of the Helen Enterprises. Now, the third party, Coffee Chrome Company Limited, came to court and put up the argument that they should not be brought into the suit, and that the defendant can only claim indemnity or contribution in third-party proceedings. Do you know why you're talking about indemnity or indemnity? Like if you issue a check, you issued a check for me, I presented the check, and I have gone to incur a loss in the sense that the check was credited to my account, the money hit the account, I withdrew the money, and then later on the check was dishonored. There was a problem with it, and then the bank is after me. They have more or less stolen the money, so I should bring the money. It's because of the check you gave me, which has caused that, isn't it? So if you look at the negotiable instruments at the Bill of Exchange Act, the Bill of Exchange Act, you see the right of indemnity in it. If you have some of these dishonored arrangement, but the third party was just trying to say that you have to go and issue fresh proceedings against me. But the court said that in the view of the court, as it as Doji actually then was, or I'll give the judgment, that the third party was not disputing the indebtedness, and the right to indemnity arises when there is obligation to indemnify. Now, it was the court's view that so long as the evidence showed that the third party was actually issued that check and so on, then the defendant was entitled to the amount of the bill, that is the check, plus interest and costs, and proceeded to enter judgment against the third party, as it were. Yeah, so apart from the Bill of Exchange or the negotiable instrument example, there are other scenarios that you've mentioned. And so when it comes to also something like the partnership, partnership, a partner is an agent, isn't it? As it were for the firm. So the partner can incur lawsuits and other things, and assuming the partner has to meet it on behalf of the firm, then the firm will have to reimburse the partner, and also vice versa, as the case may be. So you mentioned contractual indemnity. That is where you have a contract which expressly provides that a third party will indemnify someone for claims which a party may brought. Then that will be it. For example, you may have a construction contract, And construction contract, there will be subcontracting. Because when it comes to construction contract, there are various things involved. So that's why the fact that you awarded the contract to one contractor, it's not the contractor that will do everything. Various, tasks or various activities involved in the project will be subcontracted to subcontractors. So if something goes wrong and then the employer, that is the one who awarded the contract to the employer to the contractor, is suing the contractor, it may well be that maybe it has to do with the plumbing side of the building. And this plumbing side was given to plumbers, subcontracted to some plumbing company. And they didn't do their job well. But the employer, that is the one who owns the building and awarded the contract, he doesn't care about the subcontractors. It is you, the contractor, the main contractor you give the job to. So he will sue you, but then you may have the right of indemnity, as it were, from the subcontractors. And then you may want to have like a third-party procedure served on them. We also have contributions. If you look at the 15.1.1a, it talks about contribution. So a contribution claim is a claim by the defendant that if the defendant is saying that if I, the defendant, I am held liable to the plaintiff, then the third party should pay a fair share of the liability because the third party is also legally responsible for the same damage. When it comes to torts of negligence, you remember contributory negligence and those kind of things. Yes. So typically, the defendant and the third party have done tortfeasors. When I say tortfeasor, someone who caused the tort. So that's like the example that we have. The running down action, like the multiple vehicular accident. Yes, one is sued and said that yes, I ran into you because another person ran into me. So that person is also supposed to contribute in meeting the loss which I have incurred. So that is a contribution. We may also have what they call the concurrent wrongdoers, whose acts together cause the harm. So either they acted the same time. So all those are a possibility. No, I said the concurrent wrongdoers. So let's take a hospital, for example. Let's say probably a hospital and a contractor, okay, like a lab. Let's say that you have a hospital which has an arrangement with a laboratory company. Not all hospitals have their own full-fledged lab. Some may have a working relation with some full-fledged lab. And then the lab, all that they do is just to do the laboratory services. It's not a hospital. So let's suppose that and some may even come on the site. Like they may be on the site of the particular hospital, and then we'll be providing the laboratory services from there. So let's suppose that there was a case of medical negligence, and it has to do with maybe wrong laboratory diagnosis or something like that. And the person sues the hospital. So the hospital, through their doctors, caused the harm. But if you look at it, the laboratory also contributed, isn't it? Yes, so that will be giving rise to contribution. So that if it is hospital, which is sued, maybe you sue the particular doctor in the hospital vicariously, but then the hospital will say that, yes, but there's an aspect of this thing you're talking about, which we didn't cause ourselves, or we didn't cause alone, because the laboratory company we have a working relationship with, they didn't do their work well. That is why we have this situation. So we like them to also be served notice, because they are supposed to pay or contribute towards whatever you may get against us. So as you can see, contribution is really apportionment, isn't it? Just from contributing negligence, sometimes one joint tortfeasor may be given 40%, 60%, 20%, 30%, depending upon what the circumstances are. So it's about apportionment of the blame, as it were. And contribution does not require contract. So let's get that. Contribution has got nothing to do with contract. It actually emanates from tort, isn't it? So you don't need to have a contract with somebody. So it's not because they have a contract with the laboratory. That is why the contribution, because they didn't do their work well, leading them to also do the wrong diagnosis or treatment, which has landed them in trouble. That is why we are talking about contribution. Now, third party, we indicated the other day, is to be distinguished from Joinder, isn't it? We come and talk about that later, but let's look in the procedure, how is actually done. How is the third party proceedings actually initiated? And we have an idea of the type of cases in which you will get the third party procedure. Now, in terms of the procedure, how to get it, first and foremost, if you look at the 15 rule 2, or the 15 rule 2 makes the point that you have to first apply by ex parte what? Application. So application to issue and serve a third party notice shall be made ex parte and shall be supported by an affidavit. So the first step, if you are a defendant, and mind you, it's only a defendant who can apply for third party. So assuming in exams, you write a plaintiff may, completely you are wrong, isn't it? And you can be given 0 for the whole of the answer, but you don't know what you are talking about. A plaintiff, how can a plaintiff cause a third party notice? The plaintiff are the one initiating the action. If you think that you have a case against someone, one of the person defendant and one of the defendant, isn't it? Yes, you can join the person. So the plaintiff does not come in. So the defendant, you would like to get a third party. So the 15 rule 2 says that first, send ex parte application or present ex parte application to the court. And the ex parte application should be supported by affidavit. What must be stated in the affidavit? The nature of the claim made by the plaintiff in the action. So your affidavit will have to talk about the fact that, yes, you have had a rate issued against you. By the rate the plaintiff is claiming against you, the following. You can just take the reliefs which the plaintiff is claiming against you. Then B, the stage at which the proceedings are breached. So what stage is the proceedings? Is it at the trial stage, or are you still at the pleading stage? Are pleadings closed, or what? You must indicate that in your affidavit. C, the nature of the claim made by the applicant or particulars of the question or issue required to be determined. So, what claim are you making against the the third part, the proposed third party. The proposed third party, that's the person you are seeking to bring in. What claim are you making against the person? What questions do you think the court will have to determine between you and him? And here, let me say that it's not only about the indemnity and the contribution. There will be some other relief you have against the third party, which is connected or is related to whatever judgment or whatever relief the plaintiff is trying to claim against you. So you must state the nature of the claim you are making against the proposed third party. Then D, the facts on which the proposed third party notice is based. So it becomes a bit like the statement of claim, as it were. I'm not saying it's a statement of claim, but what facts are you relying on to support the particular claim you are making against the proposed third party? Assuming it's a contribution or it's indemnity or some other relief, you must explain why you are entitled to those reliefs or those claims against the proposed third party. And E, the name and address of the person against whom the third party notice is to be issued. So you must indicate the name and address, because when the court makes the order, it will have to be said. Mind you, the third party is not in the matter. He's not in the matter yet. So we don't know where he lives. We don't know how we can reach him. We don't even know him. So we must indicate the name and address of the person against whom the third party notice is to be issued. Yes. And you also realize that it's as party, the plaintiff who initiated the action. We're doing this on his blind side. The plaintiff is in the house, and then you go to court, and then you are telling the court to give you leave to have a third party procedure or notice of it issued against the proposed third party. You should not be concerned that the plaintiff is in the house, or we are doing this on the blind side of the plaintiff, as the order 1502 says that should go as party. Because, as we have indicated, the plaintiff, he is not interested in, the plaintiff has sued the defendant, and all that is interested in is to prove his case against the defendant and get a judgment and execute against the defendant. He doesn't care whether the defendant is saying that, well, I'm not the only person to be blamed for this. There are some other people. Or I also have a claim against someone which is relevant to meeting your claim what? Against me. The plaintiff is not interested. And that is why the rule says that it's the defendant's own, if you like, a private funeral or a private headache. So you don't have to break the plaintiff vote in. So that's why you go by ex parte to explain, to convince the court. So that if the court is convinced, then the court will exercise the discretion and allow the third party notice to be what? To be issued. Yes.
My lord, if I want to find out for the defendant to apply for the third party to be joined the gift, an indirect accusation that he or she will be liable.
No.
Which we think he wants someone to come and help him say.
It's not indirect admission. Good, that is a good, no, but then you've also broken the rules because other people wanted to ask questions. And I said, you have to put the questions down. So it's still sin against the rules of engagement, but once you've the 81. All right. Okay, so okay, good. So her question is that the fact that the defendant is seeking leave to have a third party notice issued against the proposed third party who is outside, the stranger to the accident so far, is it an implied admission of liability? And that is why he is looking for somebody to come. No, not necessarily, no. No, it's not implied. So that does not justify the plaintiff asking the court to allow judgment. No, it's not implied. No. Now the application is discretionary, as you can see. It's not automatic that you want a third-party notice issued and then the court will just allow you to be. Because otherwise, if it is also not properly policed by the court, it will be subject to abuse, isn't it? If you can get irresponsible or unscrupulous defendants who will just be asking for so many third-party notices to be issued, just to delay and complicate matters, knowing very well that they will not even have any things like that, isn't it? Or you can even get someone who may even arrange, just have like a arranged match, and then they will do it just to come and delay, things. And that is why it's discretionary. And so that if you look at the case of Chatworth Investment Limited, Chatworth, just like chatting with someone, Chatworth Investment Limited against Amoco, AMOCO, Amoco UK Limited, AMOCO, Amoco. The English Court of Appeal held that even where the third-party claim was connected, that is connected to the plaintiff action, the court could decline leave where the third party was not genuinely concerned with the main dispute, and where allowing the notice will cause unnecessary cost and delay. So there's a discretion, as we have indicated. And when you submit or you present the application, the merits of the claim is not to be determined at that stage. So it's not you are claiming that you have a claim against the proposed third party. It does the fact that you are giving the leave doesn't mean that the court agrees that your claim is actually what is made out. No. You may have the third party notice issued, but later on, when we go into the merits, you may not have any case against the third party. And you've been exposed yourself to heavy costs, but you just wasted somebody's time. So where the order has been given, like the court has made an order or granting leave for the third party notice to be issued, it is served in a particular way. So Form 6, let's look at Form 6. Let's go to the schedule. Page 281. I don't know the version of the rules you are using. Form 6. You notice how it is third party notice, claiming contribution or indemnity or other relief or remedy. Under 15 Rule 2.2, then title as in action. So you repeat the title of the case, the original title, the plaintiff against the defendant, and so on. Then after that, you have third-party notice. That should be stated expressly, third-party notice. So after writing the third-party notice, underneath you see issued pursuant to the order of, because mind you, third-party notice is issued pursuant to an order of court, isn't it? That is all the 15 Rule 2, you go by S party. So you must tell us, when was the order made? When was the order made? So issue pursuant to the order of the court dated so and so and so. And then 2. If you look at the affidavit, you are supposed to provide the name and address of the proposed third party. So in the notice, it will be addressed to that person. So 2. The person's name will be stated then of the address, as it were. And look at it. The third party notice, it has some of the features of a writ. Look at the form 6 closely. That in it, the plaintiff claims against the defendant, and then you state what the plaintiff is claiming against the defendant in the original writ. Then you add what the defendant is also claiming against the third party. The third party claims against you. So what the defendant said he has against the third party, you state over there. And then after that, and take notice that if you wish to dispute the plaintiff's claim against the defendant or the defendant's claim against you, an appearance must be entered on your behalf within 8 days. Or if the notice will serve out of the jurisdiction, insert here the time of appearance faced by the order giving leave to issue the notice and serve it out of the jurisdiction. After the service of this notice on you, inclusive of the day of service, otherwise you'll be deemed to accept the plaintiff claim against the defendant and the defendant claim against you, your liability to indemnify the defendant or to contribute to the extent claim. And then it goes on, dated, signed by the lawyer. So it has taken some of the features, not all, some of the features of a writ, as you can see. And essentially, you notice that, so look at this, so in exams, for example, assuming you are given a scenario and you have to draft the necessary process, or how will this person, then you make a determination that, okay, this defendant can pursue indemnity against a named person from the story. And then you have to draft the necessary process. You have to know that there are 2 things. You have to draft the ex parte what? Application, isn't it? Good. And an affidavit. The third party notice itself, because it's a form, you may not be required to draft it because it's a form. But then the application, that one, so you have to know how to draft that as well, isn't it? The motion paper and then the affidavit. So the motion paper and the affidavit. So the motion paper, just as we learned applications, the normal, the court, the title, that is the parties. And then you have like the heading, ex parte application or ex parte motion for leave to issue third party what? Notice or third party, yes. And then you have the body. Take notice that so and so counsel on behalf of the first defendant or the second defendant, depend. Sometimes we have multiple defendants. And not all of them who are asking for the third party, only maybe one. So counsel for the second defendant, applicant, will move the court for leave of an order of leave to issue a third party what notice in terms of on grounds set forth in the accompanying affidavit. Then you have dated that dash the lawyer, the name, the license number. You have to always mention the solicitor's the license number and the registration number of the chambers. It's very important. And then you do like the registrar, because when you file the process is addressed to the court. And the court, you don't address it to the judge. The court official who speaks on behalf of the court is what? The registrar. So you address it to the registrar. So the registrar, then the particular court, and so on. And then after that, you have this was ex parte, so not, and copy for service will not come because ex parte, isn't it? Yeah. Good. So if you bring a copy for service, then is wrong. Because the thing is S party. So if it's S party, who are you going to serve? So good. And so then you go to the affidavit. So the affidavit, it also has to reflect the full title of the case as we have, like just as we have for the motion paper. And then instead of writing motion, you write the affidavit in support. Affidavit in support of the motion for leave to issue the third party, or affidavit in support by write the name of the defendant deponent. But there is a type of affidavit the defendant applicant will have to depose himself. The type of, and actually, the best practice requires that for serious applications, the affected party should depose himself, and not just the lawyer's clerk. That one is not a good practice. Maybe matters what the lawyer's clerk can do. Maybe substituted service. Those kind of very basic application. And when it comes to something like injunction, if you bring injunction application before me and I look at the affidavit, then it's a lawyer's clerk who did it. Already in my head, I'm going to say they are not serious. So if the what do you call the other opponent has been able to put up some reasonable thing, you are going to lose. You want injunction, and you not come and take oath and depose the matter yourself. Your lawyer's clerk should depose matters, and you get an interlocutory injunction. No, it's not convincing, isn't it? No. The lawyer is not the lawyer is doing the professional side. The lawyer is doing but the lawyer is not the one who owns the case. You own the case. So you are supposed to speak about factual matters relating to the case. The lawyer will drive the legal side. But the factual matters, the lawyer was not there. All the happenings and not happening. You are the party, so you must speak to those things. Very soon I'll give you a break. I've seen some of you. I've had break already. Isn't it? Oh, how can you be tired? Good. So where the third party notice has been served. So if you look at the order, 15 rule 2, that's what we want to look at the form 6. Then the order 15 rule 3, service of notice and filing of appearance. So a copy of the writ and of the pleadings served in the action shall be served with every third party notice. So mind you, so it's not only form 6 which you are going to serve. Form 6 must be accompanied by the writ and all the pleadings. So the writ, statement of claim, statement of defense. If you have multiple defendants, because the rule says that pleadings, isn't it, serve in the action. So all the defendants' statement of defense, some of them may have like a separate statement of defense. They all have to be attached to the third party notice and serve on the third party as ordered by the court. So where a third party notice is served on the third party, the third party shall, from the time of the service, be a party to the action with the same right in respect of defense against any claim made against the third party in the notice, as if the third party had been duly served by the writ by the defendant by whom the notice is served. In other words, if a third party notice is served on you, you are a party, so you have to enter appearance. So the third party notice is not a writ, but in substance, form-wise, it's not a writ, but in substance, it's a sort of like a writ. The defendant is actually getting to be issued against you. So once you are served, you have to enter what? Appearance. Within how many days? 8 days. You have to enter appearance. Or if maybe it was like a notice to be served outside the jurisdiction, it's possible to have a third-party notice issue. A notice of it will be served outside what? The jurisdiction. Yeah, so then the court will have actually specified the timeline for entering appearance. Now, if you don't enter appearance, what will be the consequence? We saw it from decisive. If you don't enter appearance, what will it mean as far as yes? What will be the implication for default to enter appearance as a third party, having been served with a third party what? Notice. As far as you are concerned, as a third party, you'll be deemed to have actually admitted the plaintiff's what? Claim, as well as the claim the defendant is making what? Against him. So let's look at the directions on the 15.4. So where you have entered appearance, the defendant will have to apply to the court for directions, for the court to give directions in terms of what is going to happen now that this third party has come in. And that is important because we don't know the stage at which the third party notice was issued. If trial had, for example, commenced, and this third party has come in, has filed his response or defense, as the case may be, and the court will have to give direction. Should he file as a witness statements, and so on and so forth. So, under 15 rule 4, the defendant at whose instance the third party notice was issued will have to apply to the court for directions to be given regarding future conduct of the case. So, Order 15 rule 4.4 say that, rule 4.3, on hearing of an application under this rule, the court may, if the liability of the third party to the defendant who issued the third party notice is established, order such judgment as the nature of the case may require to be entered against the third party in favor of the defendant, or B, order any claim, caution, or issue stated in the third party notice to be tried in such manner as the court may direct, or C, dismiss the application and terminate the proceedings on the third party notice, and may do so either before or after any judgment has been signed by the plaintiff against the defendant. So as you will notice, when it comes to the direction, everything is up for consideration of the court, as it were. Assuming the notice was issued at the time that judgment has been entered, then the court will allow the defendant to have the judgment entered against the third party, unless the third party can also put up like a different story for the court to look at. Again, just like you are going for summary judgment, the third party will also be given the leave to defend the action. So if you look at the 15 rule 4, look at the sub rule 4, on application for direction under this rule, the court may give the third party leave to defend the action either alone or jointly with any defendant, upon such terms as may be just, and to appear at the trial and participate in a trial as may be just, and generally may make such orders or give such direction as appear to the court proper for determining and enforcing in a just manner the rights and liabilities of the parties, including the extent to which the third party is to be bound by any judgment or decision in the court. So the direction state is quite elastic, a number of things, including the fact that the courts can permit the third party to defend the action against even the defendant, at whose instance the third party notice was the issue, as it were. Or the court may say that, assuming judgment is entered against the defendant, it is only this portion which will be like entered against the third party and not beyond that. So it's very elastic. A lot of things can happen, but the point is about justice. What is the whole exercise or the objective of a third party? To ensure that if we have questions between the plaintiff and the defendant, which will affect a third party who is outside the case, the person should have the benefits of participating. Or if the defendant will have to institute a fresh action against the third party as a result of the claim the plaintiff has brought against him, because he has also got something against the third party. You don't need to wait for the plaintiff action to be completed before the defendant will do a new action. You allow the third party to come in, and that is why the direction state is quite elastic, and the court can give a number of orders to ensure that we have fairness and justice. What about default? If the third party default, under 15 Rule 5, if the third party defaults, as we have indicated, is deemed to have admitted the claim in the third party notice. And for that matter, if any judgment is entered, he or she will be bound by that judgment. So it operates in the same way like the judgment in default of appearance or defense, as the case may be. But it is also possible to set aside third-party proceedings. So if you are the third party against whom the notice has been issued, you may apply to set aside the notice where the claim is not connected with the plaintiff's claim. So the claim that the defendant mentioned in the third party notice, which was served on you, if you examine it and is not significantly related to the plaintiff claim, then you can ask the court to actually discharge or set aside the third party notice. Or where the relief is not substantially the same. So where the relief is not substantially the same, in other words, what the defendant is seeking against the third party is not substantially the same as what the plaintiff is claiming against the defendant, as it were. Or where the third party is not concerned with the dispute. So if there's no connection between the third party and the dispute, despite the fact that the defendant may have some legitimate claim against the third party, it will not be a basis for a third party procedure. It will not be a basis for a third party procedure. And that is how it works a bit different with the counterclaim. Like counterclaim, once the plaintiff has sued the defendant, and as we know, if the defendant has any matter, any claim against the plaintiff, you can also set up that, isn't it? By way of counterclaim. And it does not necessarily have to be related to the particular relief that the plaintiff is looking for in the yes. But third-party notice does not work that way, because the defendant, you are saying we should bring the third party in, because for the reason that you have the claim is looking against you, you think that the third party is also to be blamed or he has a role to play. So if he is not in any way connected but we have some other case against him, then that has got nothing to do with the the judgment you are likely to face from the plaintiff. So you shouldn't bring the third parties with. On that basis, the third party proceedings can be set aside. And then again, where the proceedings are oppressive or wasteful, where the proceedings are oppressive or wasteful, it may be set aside. So let's look at the I'll give you just 5 minutes break. Just 5 minutes break. Welcome back. So just before we had a break, we were looking at what the 15 rule says. That is setting aside the third-party proceedings. And it is to the effect that the court may, at any stage of an action, set aside proceedings on a third-party notice within the action. And we gave the circumstances under which the court may be moved to set aside the third-party proceedings, as it were. And mind you, it's not only the third party who can go to the court and ask the court to set aside. Especially if the proceedings are oppressive or wasteful, the plaintiff himself can also intervene. How? How can the plaintiff? Because mind you, where the person is joined to the suit, is a party to the suit. So let's assume that trial is going on. Let's assume it's still at the trial stage. And this third party is not coming, and you can see that you were just brought in just to do some kind of like a delay tactics. The plaintiff monitors involvement closely. The plaintiff can bring it to the attention of the court and say that this third-party proceedings, and then the joint, he being made a party, is actually not serving the purpose for which a third-party procedure is supposed to achieve. And it's rather oppressing me or just unnecessarily delaying. And the court can look into it. Once court, there are certain orders, when the court make it, the court can always be approached appropriately for the order to be set aside. Even injunction, when injunction is even granted, it can be set aside, isn't it? Every order. So judgment between defendant and third party. Under 15(7), where in an action a defendant has served a third party notice, the court may, at or after the trial of the action, or if the action is decided otherwise than by trial. So what are you thinking of? If the action is decided otherwise by trial, what comes to mind? Summary judgment. There should have been a rapt chorus. Summary judgment. You are not sure. Okay, or if the action is decided otherwise than by trial, on an application made for that purpose, order such judgment as the nature of the case requires to be entered for the defendant against the third party or against the defendant. Yeah, so judgment is made either after plenary full trial or some other way, summary judgment, or in default judgment, if it's not set aside. But of course, in a third party, an action where there's a third party, you don't expect that there will be default judgment, isn't it? Practically, there will not be a judgment in default of what? Defense or appearance. It's not practical and conceptually impossible. You know the conceptual possibility. If the defendant is not ready, why would the defendant move the court for leave to have a third-party notice one issued? If you haven't entered appearance, you haven't filed defense, can you get the third? And these are some of the things you also be thinking about as students of civil procedure. If you haven't entered appearance as a defendant, you haven't filed statement of defense, can you come under order 15, rule 1, 2 for a third-party notice to be issued? No. Yes, so certainly that one is out. So the otherwise here can only refer to what? Summary judgment. It can never be default judgment. It can never be default judgment. So where the judgment has been made, the court will determine what should be the portion or what should be the rule of the third party in the judgment that has been entered in favor of the plaintiff, as the case may be. Or you may also have a counterclaim which the third party has made against the defendant. Because the defendant, at whose instance the third party notice was issued, may also be amenable or liable in some way to a claim which the third party has against him, either set off or something. And or sometimes maybe be unrelated. It may be unrelated to the main action. So long as there's something related to the main action connecting the third party, and then the third party has legitimately been roped in by the third party procedure. If the third party also has a claim against the defendant, which is not even related to the plaintiff, the third party can get a counterclaim. Can also get a counterclaim against that particular defendant. So let's look at the order 15.7.2, where in any action judgment is given against a defendant in favor of the plaintiff and for the defendant against the third party. Execution shall not issue against the third party without leave of the court until the judgment against the defendant has been satisfied. Understand? Who can explain for us? So who got the judgment first? And then which other judgment? Okay.
My understanding is that the plaintiff then has it against the defendant, and then the defendant also subsequently has it against the third party. But then the third party must first satisfy the one to the defendant first before the defendant can also satisfy the that of the thing. I don't know what makes sense, but that's what it's from my understanding.
Okay, so then okay, another person. Yes, you've done well. And you want to, yes.
Yeah, like I just want to support what I
yes.
Like in this circumstance,
Yes.
If the judgment has been made against the defendant, the best thing that the defendant has to do is he has to settle with the plaintiff before attacking the third party. So other than that, before he can make his claim from the third party, he has to seek the leave of the before he can do so, because he has not finished with the plate.
Good. Good. Okay. So the plaintiff doesn't know the third party. The plaintiff has gotten a judgment against the defendant. So the defendant must actually satisfy the judgment. But unfortunately for you, the defendant, at least you know that you have somebody you are going to, attack. Yes, the court has actually said that the third party should also meet you either fully or halfway. But you will not be allowed to go and tell the plaintiff that no, wait, let me go and collect my money before I come and satisfy. So execution shall not issue against the third party without leave of the court until judgment against the defendant has been satisfied. Yes.
Well, with my question is in respect to 15.1.
15.1.
When you make the type of you have something about the contribution price.
Yeah.
And the explanation, this is how I understand that for the contribution claim, it means that you are asking that the third party will help you or will contribute
to meet the liability the plaintiff has against it.
Yes, please. So with respect to 15.7, if you would have to first satisfy the defendant before you can go for the third party. By this case, you need the third party's contribution to be able to satisfy the relief of the plaintiff.
Okay, good. You see, we say come back to the original question. And why, if you look at the 15 rule 1.2, you go by S party. The plaintiff is even not part of the decision whether the third party should be brought in or should not be brought in. The plaintiff is not interested. The plaintiff is saying that it's you, the defendant, that I have trouble with, isn't it? I don't care what you have with other people related to my problem with you. It's your own private arrangement. So you convince the court, and then the court said that, yes, you have a legitimate claim against that third party in relation to what the plaintiff is saying. So that person should be brought in. The person will be brought in. And the court has gone through the merits. And the court is satisfied that, yes, with respect to, let's assume it's a negligence, with respect to the negligent liability, which the plaintiff is going to look, is seeking against you. If you look at it between you and the third party also contributed about 45%. So the court has, for example, made apportionment of 45%. Now, the court has also said that the plaintiff has succeeded in his action against you, the defendant. The plaintiff does not have to wait for whatever time you be able to get the third party to raise whatever 45%. No. And that is why the 15 rule 7.2 is saying that execution shall not issue against the third party without leave of the court until judgment against the defendant has been satisfied. Now, if you look at it, insofar as it's saying that leave will have to be obtained until the judgment against the defendant has been satisfied, an argument could be made that it is not impossible for the defendant to go to court and make a strong case that despite the fact that he has not finished satisfying the judgment debt which the plaintiff has against him, the court should allow him to go and execute the judgment against the third party. And this is a discretion, judicial discretion, which you have to exercise. And that is why we cannot be exhaustive regarding what would be a good case, or what would be a bad case. It will depend on case-by-case basis. So it is not impossible for a defendant who has not satisfied the judgment under the original action by the plaintiff to go to court and tell the court that the judgment that he obtained against the third party should be allowed to execute it. But as I said, it is something which will have to be dealt with on case-by-case basis, as it were. So, for example, if it is about, let's say, indemnity, this is about indemnity, the court may probably not agree. But it's about contribution, the court may probably agree. Because indemnity is completely passing of the liability, isn't it? But then contribution is apportionment of liability. And from the multiple vehicle accident I gave, it can be understandable that you are just a victim of what? Circumstances. So it depends. Now let's look at the claim and issue between the defendant and some other party to the action, other than the plaintiff. Yes.
Hello. So, we see the defendant in this case is a man of straw, but the third party is a person with resources.
Substance.
Yes, and the plaintiff cannot recover anything from the defendant. What would happen in this system? Would the plaintiff go after the third party, or in such a case, the court will be more amenable to allowing the defendant to pay from the third party so he can satisfy the judgment of the case?
Good. And that is why, so the second part of your question, that's why I said that it's not completely impossible for a defendant who has lost the case against the plaintiff, but has won against the third party, for the court to allow the defendant, that's why the father has not been able to meet the judgment debt in favor of the plaintiff, to execute the judgment against the third party. So, like you said, in a typical case like that, where we have a defendant who is, of course, if you're a plaintiff, you also have to be careful in choosing your defendant. You don't have to. A plaintiff should be careful in choosing what? Defendant. Litigation is not just going to court. You don't just go to court for going sick, isn't it? Yes. The only time you will not care about the financial status of the defendant, when it can maybe landed, litigation, removable property. That one is the land that you're after. So you are not interested in whether your opponent has money or doesn't have what? Money. But when it comes to other type of cases which involves money ultimately, you have to be careful in picking your defendant. And that is why it's not all cases that you have to take to what? You have to take to court. So let's look at the other situation. Apart from the plaintiff, we have the defendant and the third party, some other. So let's look at that scenario. Order 15 Rule 8. Where a defendant who has filed an appearance claims against a person who is already a party to the action other than the plaintiff. So here, we have plaintiff against, let's say, 3 defendants, okay? And let's say that the first defendant thinks that he has a case against second defendant. He doesn't have counterclaim against the plaintiff, but he has a claim against the other defendants. He has a claim against other defendants. You cannot call it counterclaim, because counterclaim is directly in relation to the plaintiff's word claim or someone who has sued you. So, for the other party sue, you are going to have third party with the variation. You get a third party with the variation. So let's look at it. 15.8.1a. Against a person who is already a party to the action other than a plaintiff, A, any contribution or indemnity, or B, any relief or remedy relating to or connected with the original subject matter of the action, and substantially the same as the relief or remedy claimed by the plaintiff, the defendant may, subject to Rule 2, without leave and serve on that person a notice containing a statement of the nature and grounds of the claim. So the first defendant is in the case. The second and third defendants are also in. First defendant thinks that he has a claim against, let's say, second defendant. The second defendant is not the plaintiff, so the first defendant cannot make a counterclaim. But you have to serve something in the nature of what? A third party. But here, he doesn't have to go to court and get leave, because the second defendant is already a party. So all that to do is to get the notice crafted appropriately and served on him. Uh, 8.2. Sub-Rule 1 shall not apply to any claim a defendant may make in the nature of a counterclaim against the plaintiff. So as I said, for avoidance of that, the law is telling us that the counterclaim is referable only to one, the plaintiff. But if the defendant, and this particular point we are making, understand it well, because some practitioners don't understand it because they didn't get it well in the law school. You will get this. No, it's true. There are a lot of things we have to learn when we became lawyers. So we have to let you also benefit from the difficult thing we also went through. There's a lot of pressure in the law school. Your teachers cannot teach you everything. There are a lot of topics, isn't it? You have to learn some of the things on your own. So where you get the situation, you have multiple defendants. But between the defendants, or among the defendants, however you put it, you also went to Achimota, you know better grammar. Yes. So some of the defendants have claim against other defendants, not the plaintiff. If it's the plaintiff, it's not the problem. But the plaintiff, we know that you do counterclaim. Yeah. So, but the defendant inter se or intra, what you do is to get the third party notice served on your fellow or co-defendant, as it were. So that is what order 15.8 is telling us. And then 15.8.3, where a defendant has filed an appearance, a defendant who has filed an appearance requires that any question or issue relating to or connected to the original matter of the action should be determined not only as between the plaintiff and the defendant, but also as between either or both of them and some other person who is already a party to the action. The defendant may, without leave, issue and serve on that person a notice containing a statement of the question or issue required to be determined. It's not all the time that you are looking for a particular relief against a party, but maybe it's a question, a legal question, or some factual question, which you like determination, and you think that legal question or factual question is determination actually connects not only you, the plaintiff, and the defendant, but other party as well, other maybe defendants as well. You can also get that done. Because mind you, you as a defendant, you are speaking to only the case the plaintiff is making against you. The other defendant, they don't have a case against you. So you cannot be speaking in response to their case, as it were. They're speaking in response to the claim against you. But there may be some questions which you think are related to what the plaintiff is saying, which do not necessarily require a particular remedy like indemnity or a contribution or some other remedy, but you may just want resolution of that particular question. That is permissible, and that is what order 15.8.3 is speaking to. Yes, your hand was up. She's forgotten. She's answering the. Okay.
And not with respect to what respect mentions that the defendant, if in case he has an issue with another defendant, can also bring
This is supposed, yeah, I get a question. So the question is, when we said that if you have more than one defendant, and one of the defendants has what we call like a third-party claim, as it were, against a fellow or a co-defendant, must it necessarily relate to the same original subject matter by the plaintiff? Yes, it must. It must have some relationship. It must have some relationship. If it doesn't have any relationship, you have to go and issue a separate writ or action against that party. Yes.
I'm okay.
Yes. You want to reinforce a point?
Yes, please.
Okay.
Okay.
The person says it's okay. Say it's okay.
Okay, she's okay.
It's okay.
Okay. Therefore, persistent issue because clearly stated that anything that is not pleaded within what the parties have brought, you cannot rely on that. So any existing evidence cannot be brought into. In Adam versus Sononutu, the same principle was established.
Yeah, so is your case that where the pleadings, no, but don't forget that where you have like the third party. No, I don't understand. Yes. What I'm trying to say, yes, come again. No, because you said it's going to offer, that's why I'm laughing. That you know the third party, when it is made, you have to also do your own, as it were, pleadings, isn't it? Because assuming if you like the proper third party, like the one who is really outside, when it's brought in, he enters the appearance, you come for the directions. Then you make the case. The court will allow you to defend the action. You'll be allowed to file your own pleadings, as it were. Because the defendant will have set up certain allegations against you. So if you have entered appearance, you must also put up your response, isn't it? Yes. So it will not be like a question of just relying on just the existing pleading, but you also bring your own, as the case may be. But the nuances may differ depending upon the particular type of third party or what you call the similar action you are dealing with. Yeah. So let's continue. 15.8.4, no appearance where notice served under subgroup 3 shall be necessary if the person whom it is served has filed appearance in the action or is a plaintiff in the action. Good. So you don't need to file appearance because you're already a party. It's different where the third party is a third party as like a stranger to the proceeding, somebody who is what? Outside. And the same procedure which we followed will be followed, and that is how or the Rule 5 actually speaks. So you can read the details later on. It's also possible for a third party to also make a claim against subsequent parties. It's possible. So you have roped me in as a third party. I can also rope somebody in. It's possible. So if you look at the order 15 Rule 9, claims by third and subsequent parties. A person on whom a third party notice is served and who makes a claim for reliefs, as mentioned in Rule 8.1, may issue a notice on some other person in terms of those rules. So a third party can also get a third party what? notice issue, as it were. But it's not, not, yeah, it's not impossible. Let's talk on the offer of contribution before we wind up on this and we start amendments. Yes. If you want to learn amend or the system on your own, maybe you can learn that on your own. And then we can move on to something else. Yes. Yes.
I want to seek a bit of clarity regarding Rule 9 and
15.
15 Rule 9.
All right.
That's the essence of the rules and order 1, round 2, where it has to do with effective justice individual. If defendants, third parties keep ruling in other defendants, how does it go to satisfy the essence of the rules as it is?
Oh, okay, good. When it comes to something like negligence, okay? When it comes to contributory negligence, for example, it's possible to have multiple tortfeasors, as it were, or contributors. It's possible. Let me give you a typical scenario. So let's suppose that I like medical and clinical negligence as example. So let's suppose that somebody is complaining that he had her womb removed in what we call the, is it the hysterectomy or vasectomy? Hysterectomy. Okay, hysterectomy, yes. Is that the case? Hysterectomy. Good. So got the womb, let's say, removed. And let's suppose that they use a certain gadget or certain device to make certain diagnosis. And using the outcome of those device readings, they came to a professional judgment that for the sake of the life of the person, we need to do this procedure. So that was done. Now let's suppose that the manufacturer or those who are supposed to service the device, they didn't do their work well. So there was like a faulty reading. And that faulty reading was relied upon by the clinical personnel to make the judgment, leading to the procedure. And later on, the person decided to sue for medical negligence. So the hospital will be saying that we did what we did because of this thing we saw. That's why they may want to get the supplier, for example, brought in. And the supplier also come and say that, well, this is not the original factory design. There are some routine servicing. So those who do your service or maintenance, they didn't follow the instruction. That is why we have this particular situation. So they too may want to push the blame to those who are supposed to do the servicing or the maintenance. So it is possible to have that kind of situation, as it were. It doesn't happen, but our duty is to be aware of all that the law permits, so that if the situation arises, we know how to work around it. It doesn't happen all the time, but it can happen. Offer of contribution. Order 15, Rule 10. For purpose of this rule, an offer of contribution means an offer to contribute to a specified extent to a debt or damages made without prejudice to one's defense by a party to the action who, either as a third party or as one of two or more tortfeasors, liable in respect of the same damage, stand to be held liable in the action to another party to contribute towards any debt or damage which will be recovered against that party in the action. So let's look at the two and then we explain. An offer of contribution made by one party to another before the trial of an action shall not be brought to the notice of the judge at the trial until after all questions of liability and account of debt or damages have been decided. So it is possible for someone to say that some people are very understandable when things have occurred. And then they'll make offer that, okay, for this thing what has happened, I propose to bear so much of whatever debt or whatever loss that has been occasioned. Now, where there is such an offer of contribution to meet the debt or the loss, and we have third-party proceedings and so on going on, it will have to be kept away from the judge when the judge has ultimately determined liability. Because liability will still have to be determined without prejudice to the fact that someone has offered to bear part of the loss or bear part of the debt, as it were. So you don't want that to prejudice the mind of the court in making a determination as to whether the defendant is liable or as to whether the third party is liable to whatever is happening, as the case may be. So that is what Order 15 Rule 10 is telling us. What about counterclaims? So let's look at Order 15 Rule 11. Where in any action a counterclaim is made by a defendant, the provisions of this order shall apply to the counterclaim as if the counterclaim were a writ and statement of claim, and as if the person making the counterclaim were the plaintiff and the person against whom it is made a defendant, provided that such a plaintiff shall not be required to file the payments. Yeah, so as we indicated, it's possible for the third party to also make a counterclaim against the defendant. So in relation to the third party notice, the third party, as it were, is a defendant, as it were. And then the defendant at whose instance is issued, as it were, is what? Is a plaintiff. I don't use that designation. And the third party may do a counterclaim against the defendant, as it were. Okay, so we will take just a break, which does not require you getting up. Then we start amendments for the system. So look at the system just briefly before I'll start. So maybe just before we wind up, let me give you some practical rule of thumb in operating Order 15. In thinking of third-party proceedings, the basic question you should ask is, who do I want relief from? Who do I want a relief from? So the plaintiff will be thinking of what? Counterclaim. I mean, that's the plaintiff, counterclaim. The defendant counterclaim against the plaintiff, isn't it? And then if you have like a non-party, a stranger, the defendant will be thinking of a third-party proceedings. Now we must also ask, is a plaintiff claim incompetent without this person? If we're talking about the difference between Joinder and the third party, we will discuss that. So we can, in exams, if you ask to discuss the difference between the Joinder, a third party, you'll be able to do that. And counterclaim, you'll be able to do that. I actually have a question I wanted to discuss that. So what is the difference between a joinder and a third party? We discuss it. Or if you ask, if we have a joinder of parties, why is it necessary to still have a third party procedure? Can't joinder achieve the same thing? Okay, so briefly, so let's try and do the distinction. Third party proceedings, counterclaim, and then the joinder. And what lawyers often attempt to do is to join a party when they ought to issue a third party notice. That's what we're talking about. No, instead of doing a third party notice, they will join the party, which is wrong. Because if you join the party, it's different from you getting a third party what? Notice. Or lawyers may attempt to raise a counterclaim when the claim is not against the plaintiff. The defendant may have a counterclaim, but if you look at it, it's not really against the plaintiff, it's against somebody else. Or you also have a situation where they may invoke third-party proceedings when joinder is the proper route. And these errors are very serious because they affect jurisdiction in a sense, isn't it? They affect the right involved, the scope of the relief, and also binding effect of judgment, especially in future res judicata debates, as whether there's res judicata and so on. All these things will become complicated. So we have seen not long ago that if you talk about third-party proceedings, it arises where a defendant who has already been sued by a plaintiff claims another person who is not the party to the action is legally responsible to the defendant in respect of the plaintiff's claim. So basically, this is what we said about the third party. And the essence of third party is just trying to pass the liability to another person. You are not trying to run away from the liability to the plaintiff necessarily, but to say that somebody else is supposed to bear it. But for counterclaim, as we saw under Order 12, is a claim by the defendant against the plaintiff within the same action. The claim by the defendant against the plaintiff within the same action. And as we have noted already, the law treats the counterclaim as a independent or separate action, as it were, despite the fact that it's within the same claim. And counterclaim cannot be made against a non-party. It cannot be made against a non-party. Joinder, in terms of Order 4, if you remember, we discussed joinder when we were discussing, when did you discuss joinder? Joinder of parties. Cause of action and rate, isn't it?
Yes.
Good. So, joinder concerns the constitution or the composition of the action itself and is used where the plaintiff's claim cannot be effectively determined without the presence of an additional party. So if you look at the law, the basic question is the plaintiff's action defective or incomplete without this person? Can this matter not be determined? Is this person a necessary party? And the necessary party means that is his presence in the case as a party really needed before we can adjudicate the controversy? If the answer is yes, then he needs to be joined. The answer is no, then he doesn't need to be joined. So who is brought in? A person whose presence is necessary or proper for the adjudication of the plaintiff's claim. And then the person becomes a co-plaintiff or a co-defendant And we said that we don't actually write that. Do you remember? Just write the first plaintiff, second plaintiff, third plaintiff, or first defendant, second defendant, third defendant. You don't write co-defendant. So when they do that, it's a bad practice. Now, unlike third-party proceedings, joinder affects the plaintiff's cause of action directly. Third-party proceeding does not necessarily affect the plaintiff, but joinder does. And joinder, as we have seen, exists to prevent, fragmented adjudication of the plaintiff's claim. You know other one, as you be quoting it. We want to avoid multiplicity of what? Suit. So typical cases where you may have joinder, especially when it comes to co-owners of land or joint users who are sued by the plaintiff, or necessary parties in land litigation, companies and directors where the relief cannot be separated, as it were. So the basic thing we have to ask, as I said, as whether you have to go by joinder or third-party proceedings or counterclaim, you ask yourself, who do I want a relief from? Do you want a relief from the plaintiff? If you want a relief from the plaintiff and you're the defendant, you have to think of what? Counterclaim. If you want a relief from a non-party, somebody who is outsider, then what do you have to do? Third-party proceedings. Now, with respect to joinder, you also ask the question, is the plaintiff's claim incomplete without this person? If this person you are thinking of, if he is not added to the case, will it make the case of the plaintiff incomplete? If the answer is yes, then joinder will be what? Will be yes. But if it's no, then it's not a joinder, but probably is a third-party proceedings, isn't it? It's a third-party proceedings. And I'm going to give you this example. Let's say, especially when it comes to land, let's suppose that you bought a land. Let's suppose that the farmer bought a land from Kwaku, and Kwaku has so Kwame bought this land from Kwaku, and Kwaku is laid a claim to the land that the land is for her, and that she got it from some other Lodia or some other people. So Aku sues Kwame. So Kwame is the defendant. Aku is the plaintiff. Aku is looking for declaration of what? The title, and so on. And then Kwame also sent up the defense that I bought this, appeal valuable consideration, appeal the due diligence, and so on and so forth. Now, if Kwame wants to avoid losing out or having to worry himself later on, if eventually Aku should win, it will be prudent to get a third-party notice served on Kwaku. And then Kwame is saying that because he paid the valuable consideration to this, isn't it? And you remember your landlord. So what sort of a covenant is implicated in the land transaction between Kwame and Kwaku? What covenant? Assuming if Kwaku succeed, what covenant will have Kwaku which, or in the terms of the contract between them, what will have which? If you take somebody money to convey land, Are you not implying that you have a title?
Yeah.
Isn't it? So assuming, so if Kwame may not need to just fall for you as a witness. When you are thinking of your money, especially if you pay the valuable work, inspiration, or some, you may want to, is there advice to do something?
If the others one, they have the back.
Yeah, so it's possible to have a third party proceedings. I want us to start amendment before we go. So please look at the system. Look at the system.